I'm Dr. Jan Ewing. I'm an assistant professor in law here at Homerton. I'm also a director of studies. I'll explain what that is in a moment. And my specialism is family law, and I supervise land law as well. So what I'm going to do today is we're going to think about why you might want to study law itself, why law at Cambridge, and in particular, why law at Homerton, a little bit about our application process. And then we're going to give you a little bit of a law taster session. I'll do a taster session of just a one small area of family law. And then at the end, I'm going to give you a kind of scaled back version of that in the format that you might get it in an interview. Obviously, if you do apply, it will be a different set of questions that you'd be asked in the interview, but hopefully it gives you a little bit of a flavour as to, how some legal facts might be presented to you in an interview and how we expect you to handle those. Obviously, every college has a very different system. So this is only a rough guide. But in terms of why law, 3 years is a long time in your life. So you really need to make sure that you're making the right choice for you. Law, I would say it, but it is a very intellectually stimulating subject. The skills that you develop in terms of problem solving, critical analysis can be really useful in whatever career you choose to go on to. So lots of people obviously decide on a career in the law. That might be as a solicitor or as a barrister, and a degree in law at Cambridge will prepare you for both of those, because often when you're starting out, you're not quite sure whether you want to go down the solicitor route or whether you want to go down the barrister route. So both will be open to you if you do a degree at Cambridge. I would just say, law is intellectually stimulating, but it is also, an intense subject. There's a lot of ground that we cover. So you need to be really sure that it's the right subject for you. So I think, I was a family lawyer for years before I entered academia, and you saw people that came into the law maybe because they thought, it was a well-paid career. And certainly in London, newly qualified solicitors are getting paid up to 150,000 a year. It's a well-paid career. But unless, it's something that you actually want to do, because it is hard work and long hours, sometimes people did it for a couple of years and just, they either stuck at it but didn't enjoy it, or they changed careers after a couple of years because it wasn't actually what they wanted to do. They were attracted by the salary, or perhaps the status, or perhaps their parents wanted them to be a lawyer. So you really have to make sure that it's the right choice for you. And of course, not everyone who does a law degree will go on to be a lawyer. It's actually a really well-respected degree in its own right for a number of other careers. So let's just talk a little bit about studying law at Cambridge. It is a big investment that you're making. Why come to Cambridge? And as Lindsay mentioned, we are very highly ranked. So for 2026 for law, we're third in the world university rankings, first in the UK and third in the world in the QS World University Rankings, third in the world in the Times Higher Education World University Rankings, first in the Complete University Guide for UK universities, equals second in the Guardian's University League table. So, we are a highly respected, world-renowned university when it comes to law, and we don't rest on our laurels because that place can easily be lost. So, if you come to Cambridge, then you know that you're going to be taught by world-leading experts in the field. And so understandably, places are very competitive. So in 2025, we received 7 applications for every offer that we made. So it is very competitive. We took in 2025 232 students in total across the whole of the law degree, across all of the colleges. In terms of why, we're going to talk about why law at Homerton in a moment, but in terms of the Cambridge experience, so you'll get 8 to 12 hours of lectures a week and 2 to 3 hours of supervisions. And one of the unique things about Cambridge is that you're taught in very small groups. So you get your teaching in the lecture, but then in small groups that we call supervisions, you'll then unpack that teaching. So you might consider some of the academic debates, the need for legal reforms in a sort of essay style debate, or we might look at a problem question and apply the law to that. But we do it in very small groups of 2 to 4. So that means, you get a really good chance to deepen your understanding. It does also mean you can't hide in those small groups, but it's just a really deep way to learn from your supervisor. There's lots of opportunities across the university in terms of studying law. So we have lots of kind of moot court type situations where you can take part in a mock trial. They obviously are really good for your CV to show that actually you can think on your feet, you can present a case well. So we have lots of opportunities, and I'll talk about the Homerton one a little later, but we have opportunities across the university to take part in moot courts. You'll get very regular feedback on your written work. So in each subject that you take, you get usually 4 pieces of written work across the year. They don't count towards your final grade, but you get individual feedback on that so that you hone your techniques ahead of the exam so that you can really achieve your potential in the exam. Obviously, because of our standing, we attract a lot of outside barristers' chambers coming in to speak to our students, solicitors' firms coming in, world-class leaders in their field coming to Cambridge to speak in all sorts of extracurricular activities. So there's a lot going on and a lot of opportunities for you, and also to build connections, which is partly why, as Lindsay said, we are ranked first in terms of employability. As Lindsay also said, doesn't matter what college you end up in, the actual law course itself is the same across the board. In your first year, you'll have 4 papers: criminal, tort. Tort law is essentially the law of negligence that doesn't amount to criminal negligence. It's what's called civil negligence. So criminal law, tort law, constitutional law, and civil law you learn in your first year. Everyone takes those papers. There's exams at the end of that year, but they don't count towards your final grade. So again, it's about learning the techniques for answering the questions well for when it does count in your second and third year. So your second and third year marks are equally weighted. And in your second year, everyone takes contract and land. And then you've got 3 choices, basically. So one of them is my paper, family law. But if you look on our website, there's a whole array of papers that you can choose from. And you do the same in your third year, 3 choices, but that year you take equity and EU. What this does mean, because we have these consistent subjects, it does mean that any requirements in terms of becoming a solicitor or a barrister, and we will have covered all of the core papers that you need in order to pursue. It's essentially it's only the barrister's option now that has particular requirements, but we cover those requirements. So whether you choose to be a solicitor or a barrister, you'll have taken the core subjects that you need to take. But plus you'll have had an opportunity to take 3 papers each year in your second and third year. And in your third year, you also get a choice of some half papers. If you're particularly interested in some niche areas, perhaps environmental law, succession law, for example, they can be done in half papers. And you also, in your third year, get the opportunity to do an extended piece of written work. So, there are various seminar papers in family. We have one called Family Law and Society. So if you're particularly interested in a particular area of law, it means you could take that paper in the second year, but then in the third year, you could do a seminar paper in that area where you do an extended piece of written work in lieu of one paper. So, students who take that option seem to really enjoy it because it just gives them an opportunity to really, investigate and do some research on an area of law that they're really interested in. And it does mean, of course, that you have one less paper to sit in terms of exams. And as I say, everybody does that, regardless of your college choice. In terms of entry requirements for the university, A star AA, and that's what we ask for Homerton as well, or 776 points at higher levels for the IB, International Baccalaureate, and also a strong LNAT score. So as Lindsay mentioned earlier, there is a compulsory exam called the LNAT. I'm sure if you're thinking of law, you'll have been talking to your schools about the requirements. So that's a national exam that certain universities require, and at Cambridge we require the LNAT. So you must, if you're thinking of applying to Cambridge, you must begin to investigate the LNAT, because if you don't have the LNAT, you won't get an offer from Cambridge. So the LNAT, as I say, it's a national exam, and obviously we're looking for a strong score in your LNAT. We don't have particular A levels that we ask you to take, but lots of students find that if they've got some sort of maybe English literature or history, for example, something that's involved essay writing, that can be particularly helpful if you're doing a law degree. But actually we take students from all sorts of STEM backgrounds as well. In terms of law at Homerton, why study law at Homerton? Well, we have an intake of about 10 students a year. That means that there's about 30 students, undergrad students, taking law at Homerton. So we are a small, really well-knit community, and having that well-knit community can be really helpful, just so that you can chat to the people in your year above about internships perhaps that they've applied for, or chat through subject choices for your following year, that sort of thing. So we have lots of events where the whole of the student body taking law get together. So we have some semi-formal events. The students can join the Homerton Law Society. We've got lots of social stuff going on. This year we've had a pizza night. We're going to be having a barbecue. We do, as Lindsay mentioned, have specific funding options open. The College Hardship Fund, or the financial assistance awards. And we have the picture there is of last year's Homerton Moot. So the person in the middle is on a Judge Perushko, very kindly attends and judges the final of our Homerton Moot. Last year we had it up at Cambridge County Court. This year we did it internally so that His Honour could join us for a semi-formal dinner afterwards, so that he could continue, the conversation with the students. So, it's incredibly generous of him to come and do that for us. And as I say, we have options for mooting generally across the university, but the Homerton Moot is a slightly smaller moot, but it's, it's still really, really good practice at honing your advocacy skills. And it's fabulous from an employment perspective, if you can say, I was a finalist in the Homerton Moot, I won the Homerton Moot. So we have lots of opportunities like that. There are opportunities, as I say, across the university to moot, and there's opportunities across the university to engage in all sorts of competitions. So, for example, the Cambridge Commercial Negotiation Society run an annual event, and the finals are in India with teams from across the world. And Cambridge has actually won it, for the last 2 years, the international finals. I mentioned that because two Homerton students, two of our third-year students, have won the competition internally this year. So there were 64 pairs of negotiators. So what's that, 128 people taking part in that competition. And the two Homerton students were the winners of that. So they are flying off to India in the summer to compete in the World Finals. So there's just so much going on for you to take part in. And in terms of, your academic development, each student has a director of studies. So my colleague, James Mannering, who's also an assistant professor in law at Homerton, he is the director of studies for the first year students. He also teaches crime and tort. So he would supervise you if you came to Homerton in your first year for those two subjects. I'm the director of studies for the second and third years. So in your second year, I'll teach everybody land law, supervise land law, and I'll supervise family law in your second, or if you choose to do it in your third year, if you choose that as an option. Land law is a compulsory, family law is a elective subject, if you choose to take that paper. But we have a system at Homerton where we each, between James and I, supervise one of your core subjects, because then even if you don't take family law, I've had an opportunity to teach you. So I'm in a much better position to gauge how you're doing academically, and then to, be able to liaise perhaps with the other supervisors, knowing you not only personally, but at an academic level as well. And you're also assigned a personal tutor, so to look after your pastoral development. So as your director of studies, I look after your academic development, but you're also assigned a personal tutor for your pastoral development. So it is a really, really supportive community at Homerton. We are slightly out of the centre of Cambridge, but lots of the students say that actually they like that, because they can come sort of home to Homerton after their studies during the day, and it, if you visit the college, we have beautiful grounds. It's just a very collegiate, welcoming place for students to be. I'm sure you're going to hear from Beth, one of our third year students, later on. I'm sure, I hope that she'd agree with that. So as I say, the uni offer is the same as the Homerton offer is the same as the uni offer. So we expect A star AA. Um, actually, our average grades tend to be A star A. We take 8 to 10 students per year, with no specific subject requirements. But as I say, lots of students come with maybe history or English literature or some sort of humanities A level where they've had to do some essay writing. But that wouldn't preclude you in any way if you're not doing those A levels. In terms of what we're looking for in applicants, obviously that's really important to you today. So we're looking for your academic ability and potential, of course, but we're also looking for genuine, motivation and enthusiasm. So if you are invited to an interview, you'll be given what's called a generalist or a skills-based question. And a typical generalist question will look at your motivation to actually take law in the first place. And there, so, you need to think ahead of an interview, well, actually, what is my motivation? And this is, it's not a vocational course, it's a taxing academic course. So we're looking at what academically interests you in studying law, as opposed to, well, I want to be a lawyer, and so I've got to do a law degree. So think about what actually motivates you to study the law, because you'll often get a question like that. And we need to know that you're going to be a good fit. So you'll be asked a skills type question. And we're going to do that towards the end of the session so that you get a flavour for what that might look like, to see whether you can think like a lawyer. Now, of course, we don't expect you to have any legal knowledge necessarily, but it's can you, take a set of rules and extract from that set of rules the relevant rule that would apply in a given circumstance. So we need to know that you'd be a good fit, that you can, you have the kind of inherent ability to think and apply a set of legal facts and rules. Of course, as I say, your first year is about honing those skills, but we're looking for some inherent, fit with the course. And if you do want to be a lawyer, some sort of vocational commitment to actually becoming a lawyer. In terms of what we use to assess you, obviously your academic record, your personal statement, your school's reference. You wouldn't be required to submit written work for law, but then your performance in the actual interview itself, we look at. And we look at what we call contextual data. So we're looking at, not only your predicted grades, but also, your the school that you're going to, and that sort of thing, to contextualize how well you're doing. For the interview in law at Cambridge, or certainly at Homerton, you'll have 2 interviews, and each interview is conducted by 2 people. So, there'll be 4 people altogether that are assessing you. That does mean, that to try to make it as fair as possible for you, that, hey, if you got a bit tongue-tied or perhaps made some missteps in one of your interviews, you may do better in the other ones. So we really are trying to give you the opportunity to show, just how good you would be and how worthy of an offer that you are. So and there's a lot of work goes into that. And as Lindsay said, sometimes if you had applied to a different college, and for whatever reason they were oversubscribed in the winter pool and sometimes in the summer pool, we can select students from there as well. But obviously, primarily the offers are made to the students that we've interviewed and we think will be a good fit for the course, and of course then go on to achieve the grades that they need to achieve. So those that get the offers, they are genuinely motivated. They, we're not expecting you to know anything about the law itself, but we're looking at, can you sort of absorb what's being asked in the question? It's absolutely not a problem at all in the interview, to ask the interviewer to repeat the question or to rephrase the question. We'd much rather you thought carefully and didn't rush to give an answer that you may not have been your best answer. But we're looking for, can you extract some relevant information from a given set of facts? So sometimes we'll give you those facts in advance of the interview to read through, as in very shortly in advance, released just before your interview. Sometimes you'll just be given that information orally, and then you'll be asked to apply those sets of rules to a fact pattern at an increasingly nuanced level. Of course, we want you to be engaging and enthusiastic in the interview, so be really positive and just keep going. Even if you think you've made a mistake, actually, especially if you're going to be lawyers, in front of judges, you will sometimes make mistakes, but you've got to keep going. So we want someone that's, can think carefully and can, maybe recover if they've made a bit of a misstep. We're not expecting you to be perfect, but we want you to be engaged and enthusiastic. If you are offered an interview, it's always, we're not expecting you to have legal knowledge, but if you're genuinely motivated to pursue law, then you might have a general interest in maybe legal developments that are going on in the news and that sort of thing. Also, do make sure that if you've referred to anything, anyone that you've read or any cases or whatever that might be in your personal statement, do make sure that you brush up on them, because you could well be asked about that. Something that you've raised in your personal statement, the interviewer could ask you about that, and we can quickly ascertain the people that maybe put something because they think it might impress the interviewer, but they haven't actually read that person. Yeah. And be enthusiastic and be engaging. Just in terms of where to do it, just make sure that you're in a quiet place with a good internet connection, that you're not hungry, that you've got a drink, because if you're nervous, sometimes your mouth will dry up, that you have pen and paper so that you can write down what you're being asked, that you've thought in advance about why you want to study law, and as I say, you've looked at your personal statement again. Okay, that's some background on law at Homerton. I'm going to give you just a taster session. Now, obviously, if you do come and you do the family law course, this would be unpacked over several lectures and supervision sessions. So I'm trying to sort of pack into a very short time some facts about a family law situation. But I'm going to give you a few slides on a particular area of family law, and then we're going to just I'm going to kind of rephrase that in a way that it might be presented to you in an interview. Okay, so we're going to talk about what we'd call high net worth cases in family law. So a high net worth case is a case where there's plenty of money to go around. Everybody's needs can be met. Everyone's needs for housing, everyone's needs for income can be met, but there might be money left over. And it's how do we approach those cases? And I'm going to just give you 3 cases. As I say, we're only scratching the surface a little bit here, but I'm going to give you 3 cases. All of them are either House of Lords or what became the Supreme Court decisions that are really influential in family law. So the first case is White and White. And there, what the court said was that the objective, if we're dealing with finances on divorce, is to achieve a fair result. And a fair result is one where there's no discrimination between what they call the breadwinner and the homemaker. In other words, if one person, typically the husband, has been the main breadwinner, has got the high-flying career, and the other person has looked after the children, their contributions will be seen as equal. And that sounds entirely, as it should be, you would have thought, but actually pre-White and White, that wasn't necessarily the case. Pre-White and White, we gave the wife what she needed, and if there was any excess, by and large, the husband kept it, if the assets were in his sole name. So really unfair results. But White and White underscoring we need fair results that don't discriminate. And as a general rule, White and White says that we measure things against what they call the yardstick of equality, and we depart from it if there's a good reason to do so. So that good reason might be that one person needs more, or that good reason might be that one person has introduced lots of assets. Miller and McFarlane, so they were what's called conjoined appeals. So Miller and McFarlane were heard together. And that established that in most everyday cases, needs is the driving factor. Lord Nichols there said the search for fairness usually begins and ends with needs, because in most cases, people are just getting by. So if they separate, and you're trying to split those assets and income across 2 households, there really isn't anything left over. And in those needs-driven cases, the source of the asset is just not important. So if one person brought in an asset into the marriage, but it's needed at the end of the marriage to meet the needs of maybe the primary carer, who's often the mum, then the court's not interested in where that asset came from because it's needed. And as I say, in most cases, the search for fairness begins and ends there because there is nothing left over. But in high value cases, we might depart from equality if there's what's called non-matrimonial property. So to determine if something's non-matrimonial, Miller and McFarlane established that we look at the source of the asset. So was it premarital, for example, something that someone brought into the marriage? Was it acquired during the marriage because of a gift or an inheritance? So they look at the source of the asset to decide whether it might be non-matrimonial. Anything that's been acquired jointly, and usually the family home is considered to be matrimonial. But as I say, depending on the source, depending on the length of the marriage, because the longer the marriage, the more likely you are to have intertwined all your assets. And depending on how you conducted your financial affairs. So if you have an asset that you kept very, very separate and you didn't rely on it between, you didn't share it in any way, then it's more likely to be non-matrimonial. And then the third case that we look at is a case called Standish that says, hey, what starts off as non-matrimonial may become matrimonial through a process of matrimonialization. In other words, even if it was one person who introduced it, the longer the marriage, the more likely it is that you've shared it. And if you are treating it as shared, well, it's become what the Supreme Court in Standish said, it's become matrimonialized. So, and it's therefore open for sharing afterwards. Okay, of course, in real life, we'd be going into all of this in a lot more detail. But then let me show you how this might be presented to you in a scenario. And we're going to just work through in the last period of time that I've got with you. We're going to work through some different scenarios, and I'm going to ask you to apply and put into the chat what you think might be the case in each of these scenarios in terms of who might be getting what. So if this was, because we don't expect you to have any prior knowledge of law, if this was a family law question actually in the interview, you might be given some information, and it's quite likely that that would just be given to you orally. So, you'd need to take a note of it, but you might want to just take a quick photo of that slide. But you would be told something like, look, in family law, there's a rule when a couple is divorcing that if the combined assets are only just enough to meet the parties' needs for housing, then the source of the asset is immaterial, because it's going to be required to meet the needs of the spouse who has greater needs, and that spouse is often the wife, if she's going to be the primary carer of any children. But if the parties' needs generously assessed can be met, in other words, they're a wealthy couple with plenty of assets to meet their needs, and still, after needs are met, they'd have lots of assets left over, then when we decide whether to allow a party to keep an asset in their sole name, we look at the following. The court looks at the source of the asset. So did one party bring it into the marriage? Or was it acquired during the marriage because of a gift or an inheritance? So the source of the asset is important. They look at the length of the marriage, because the longer the marriage, the more likely it is that you'll have shared your assets. And they look at the way in which the parties arranged their financial affairs, because, as I say, the longer the marriage, the more likely it is that people have shared the asset. But if they haven't shared the asset and they've kept it very, very separately, then the courts might allow you to keep that asset that's in your sole name. Okay, so with that in mind, obviously you've had the benefit of a little bit of background to the 3 Supreme Court cases, but with that in mind, and the test that as to what might be non-matrimonial, I want you to consider the following, and I'd like you to put in the chat whether you think the husband is going to be able to keep the asset that's in his sole name in each scenario. But if you can, why as well, why you think he might be able to. So we've got a couple, John and Jane. They've got a child who's 2. They're separating. They're married, but they're separating. And the child is going to be living predominantly with Jane after the separation. So my question to you is, will John be able to persuade the court to ring-fence the asset in his sole name? In other words, to allow him to keep that asset that's in his sole name so that it's not divided between the parties. And in this first scenario, I'm going to give you 4 different scenarios, but in this first scenario, please assume that the couple have been married for 10 years and that the asset in John's sole name is the small 2-bedroom home that the family live in. It's worth £200,000, and John had bought it the year before they got married, but it's in his sole name and the couple don't have any other assets. Is he going to be able to keep the asset? And if so, why? So I don't know if you can still see the screen, because I need to obviously look at the chat. Add to the chat if you think that in that scenario, John's going to be able to keep the asset. So the only asset they have is a small 2-bedroom house. It's in John's sole name. He bought it the year before. So Ellie has said, I think you'll have to give the asset as they're married for a long time and Jane will mostly care for the child. Ian is saying because it's needed. We've got a few answers here, good answers here. The fact it's a family home, it's needed to meet Jane's needs for the child's housing. Court would almost certainly include the house in the matrimonial pot. And John wouldn't be allowed to ring fence it. Ian, that's a pretty perfect answer, to be honest. Abir, no, as despite being bringing it into the marriage, length of the marriage being 10 years, and it was shared for 10 years. Yep. I think everyone's basically saying no. Isikan, despite the fact that John brought the asset before he married Jane, Jane's needs outweigh, and she'll need it. Jane's needs trump the yardstick of equality. Yep, excellent. What was particularly good about that, some of those answers was that you were using the tests. You were picking up on, for example, the yardstick of equality there, and so yeah, okay. I can keep the chat on as well. That's good. Okay, so second scenario. The couple have been married for 10 years, as before. The asset in John's sole name is a small 2-bedroomed house worth 200,000, as before. John bought it the year before they married. But the couple have rented it out throughout the marriage, and they've got other assets in their sole name totaling 4 million, which is more than enough to meet their housing and other needs. Is John going to be able to keep that the 2-bedroom house, and why? First answer in is from Raf. Personally, I believe John should keep possession as the other assets may meet the needs of the house. Valeska saying the house is no longer a necessity as other accommodations available. Rose, John is able to ring fence the asset as Jane's needs as the primary carer will be met. Yeah. So I think all of you are saying essentially that John's going to be able to keep the asset. Yep. He bought it in himself, so it's premarital. And the other assets will comfortably meet the family's needs. Yep. So I think you're all agreeing, and that's entirely right. That is what would happen most likely. Okay, third scenario. Couple have been married for 5 years. The asset in John's name is a £1 million in a bank account. It came from an inheritance that John became entitled to 6 months after they married. The couple have other assets totaling 10 million, more than enough to meet their needs. And the inheritance is sat in John's bank account, earning interest without either spouse using it. Is he going to be able to ring fence that asset, do you think? Valeska says it wasn't shared. The time they were married was shorter and there are other suitable assets. So yes, he can keep it. Rose is saying because of the length of the marriage, it's less likely to be matrimonial. It's inherited. Well done. Jane's needs are met. Yeah. Ian, because the party's needs can be met. Iron's has just jumped off the screen a moment. Iron, because the party's needs can be fully met without relying on the inheritance, because the inheritance was kept separate. It's a relatively short marriage. They're likely to ring fence. Yep. Ben's saying that the assets should be kept as well. Wasn't shared. Other assets available. Yep. Excellent. Last scenario. The couple have been married for 20 years. The asset in John's sole name is a holiday home in Scotland worth 1.5 million. It was inherited. John inherited it 6 months after they married. They've used it frequently for holidays over the years. And the other asset is the 2-bedroomed house in their joint names in London worth 750,000. Is John going to be able to keep that? If so, why? If not, why? Anyone brave enough to put an answer? Okay. Oh, they're flooding in now. Because the marriage was long, Ian says, the holiday home was treated as a shared resource. Yeah, the remaining assets may be insufficient to meet the parties' needs. The court's likely to include the home in the matrimonial pot, meaning that John wouldn't be able to ring fence it entirely. Yeah, good answer, Ian. Valeska says it was inherited. It was shared, but they have other assets. They do, but because it was shared, because the marriage was long, because it was inherited very early in the marriage, and because the other assets, you know, if they're 2-bedroomed, it's only a 2-bedroomed house, and they'll each need a home. So it's likely that at least some of that holiday home would be shared. Okay, there you go. And that just gives you a bit of a flavour as to how some legal rules might be presented to you and how you might be asked to apply those rules to a fact pattern. But you see how you'd never be expected to know what the court, what the Supreme Court decided in Standish, but we would give you a set of rules that essentially summarise what the Supreme Court decided in Standish and ask you to apply them to a set of facts. Okay, so we are joined now by Beth, who is one of our star third-year pupils, has done phenomenally well across the course, and is also kind enough to be our subject rep for this year. So if you've got any questions, I think Lindsay's back, so you can put them in the Q&A session. And yeah,
in the pursuit of doing law as an international applicant, one needs to be well versed with the British law, jurisprudence of his native law, or the international law. So it's asking, yes, what would you need to know?
I wasn't sure if Beth was about to answer there, but
okay.
You can take an option in international law. It's one of the optional papers, but obviously the law that you learn will be the law of England and Wales, because England and Wales is one jurisdiction. Scotland's actually technically another jurisdiction, so it'll be the law of England and Wales, except that there's a compulsory paper on EU law and there's an international law option. And then, of course, lots of the options like human rights, for example, you're looking at the jurisprudence from the European courts and things. So there's lots of opportunities, but you wouldn't be disadvantaged in any way because you're coming from abroad, because we're not expecting you to come with any knowledge of the law. That bit we teach you. I don't know if you've got anything to add to that, Beth.
No, nothing to add.
Yeah.
Okay. So next question. What is a strong LNAT score?
Slightly depends on the year. So, you know, 30-ish is a strong LNAT score. But you get a score, you get your LNAT score, but you also get then scored on your essay. So we take your LNAT essay. So we take the two scores together, and of course we look at that contextually. So alongside, all of your other achievements. So we never decide just on LNAT scores. And different years, the scores can fluctuate a little bit each year. So yeah, but around about 30.
Okay.
Yeah.
Thank you. Thanks so much for the webinar. I was just wondering if a law-based EPQ would be at all beneficial for an application for law at Cambridge.
Did you do a law EPQ in any way, Beth?
No, I didn't do an EPQ, and I only did 3 A levels as well.
Yeah, yeah. So, of course, if you've done a law EPQ, you've probably looked at some case law, you've probably looked at some statute. So, it certainly isn't going to work against you, but it's not. Do not worry in the least bit if you haven't done an EPQ or you've done an EPQ and it's not in law, because it honestly, most students won't have done an EPQ and they won't have done it in law. So if they have, yeah.
Thank you. How did you prepare for the LNAT? So maybe one for
Beth.
Beth.
So I think for the multiple choice part, I definitely did the practice test on the website. I think when I did it, there was only like one on the website. I also bought a textbook. I didn't find it that helpful because I think it was quite different to the style of exam. So I'd say definitely be guided by what you see on the website, because that will be the most accurate. I guess in terms of essays, that's something that is a bit easier to prepare for. I'd say there's a good YouTube channel actually. Someone at Oxford who talks about admissions, and I think he's done a few things on the LNAT and about how to write a good essay. I'm really sorry it's not very helpful because I can't remember what it was called, but I definitely say like making use of those kind of resources, like people giving tips on YouTube and stuff. It's a simple tip, but that does help. And in terms of essays, yeah, just learning to argue, look at what kind of questions have come in the past and just do practice essays, I'd say, is really important, and learn how to argue concisely, and learn how to structure your answers as well. That's important, I say. Learn what a good essay structure looks like, be concise, and make use of online resources.
Thank you very much. Is there any further reading we can do on family law following the session to deepen our knowledge?
So you can subscribe. There's a thing called Family Law Week, and you can subscribe for free. Now, don't sort of be put off, because there is a bit that you can pay for to register. You can register and have a paid for service, but actually, Family Law Week, you can register for free, and it just gives you, hey, here's the recent Court of Appeal decisions, here's some recent Supreme Court decisions and things. So yeah, if you are particularly interested, you can do that. There are legal commentators like Joshua Rosenberg. You can subscribe to, because he does weekly, or depending on what's happening in the law. He's the BBC's legal correspondent, but he does again free update on interesting things that have happened in the law that week. That's quite a good one, just for your legal knowledge generally. Obviously not just family law, but legal knowledge generally. So yeah. But we don't expect you to have legal knowledge. That's the thing. So, we discussed those 3 cases, but the scenario that I gave you didn't refer to the 3 cases or expect you to have any prior knowledge. It's about, okay, if that's the rule, how does it apply to this set of facts? Yeah. But a general interest in what's going on in the law, obviously, is going to stand you in good stead.
Thank you. What is the greatest difference between tort and criminal law?
One's criminal and one's civil. So, for example, the test is different in a civil case. The test in a civil case is on the balance of probabilities. Criminal liability has got to be beyond reasonable doubt. Other differences, Beth?
Tort law is only private law, whereas criminal law kind of crosses the public-private divide. It's a bit of both, and it's the state who's prosecuting the person, whereas in tort law it's 2 private parties suing each other.
Yeah, so because it's civil, it's between, so it will be, for example, someone suing the council because they tripped on a broken paving stone, for example, or someone suing somebody else because they negligently caused a car crash or something like that. So it's 2 individuals, or an individual suing a company, but it's private people, as opposed to criminal, which is the state prosecuting you.
Thank you. My friend applied to Homerton last year. Can he apply to Homerton again with the same personal statement and written work, or why might it be better to apply to a different college?
There'd be nothing to stop him applying again. The question doesn't say whether he got an interview or not. If he didn't get an interview, then he might want to look generally at his personal statement. Is there something that he could improve on his personal statement? So there'd be nothing to stop someone applying again, and it wouldn't, I can say apply to a different college, you're more likely to get in, because I think probably if you didn't get an interview for Homerton, much better to actually look at the personal statement and see whether you can tweak that and make it more compelling. Yeah.
Yeah, thank you. Regarding the LNAT, what date should I apply or have taken the test by? Because the LNAT website and the Cambridge website seem to contradict each other in places.
Okay, so I don't know, without looking at the website, I don't know where they contradict each other.
I guess if you just give the deadline, if you have it.
Yeah, I don't.
That's okay. So it
there is a
should.
conflict. Why don't you make sure you've done it by the earliest date?
Yes, that's probably best. I know that there is some tests have a specific date. I think law is very much quite a wide window,
Yeah.
during which you can do it. So just make sure that you have done it in time before, before the deadline. You want to be prepared, especially because test centers can book up. So make sure. Regarding the application process, why do people, or what are the benefits of applying to a specific college? if you just decide to do an open application, will you have an input on choosing a college later down the line?
So you'll be allocated a college if you do an open application. So you know, there's no magic formula that you're more likely to get an offer if you specifically choose a college. As you know, as you mentioned earlier, and obviously some of the, you know, the Trinities and those sorts of colleges are hugely oversubscribed. Did you apply directly to Homerton, Beth?
Yeah, I did. Yeah.
And what made you choose Homerton over anywhere else?
I think one of the major factors was that it had the highest proportion of ensuite. But also
Yeah.
I mean, when I was choosing between this and another one, and I think I just like the feel of it. Like if
Yeah.
you get the chance to visit, I think feel is a big thing.
I think it absolutely is. So what you may not know is that actually even the academics, you know, so you get your sort of I came initially to cover a maternity leave, and you get your offer from the university, but even as an academic, you then have to choose a college. And I visited a few colleges, and yeah, it was the feel of Homerton. It is a special place. It is. So I would say visit, and obviously not just Homerton, visit some others. And you know, times are tight. So the fact that we have not only ensuite accommodation, but that it is a little bit cheaper than some of the other colleges might help. You know, the fact that some of the other colleges are very heavily oversubscribed. So if you go into the pool, and actually some of our best students over the last few years, we've picked from the pool. So it's not, if you don't get your first choice of college, it's not the end of the world. But obviously, I'd say much better to have an offer than risk going into the pool, because you know there's a lot of students there. So yeah, but there's no magic formula that you're more likely to get a place if you do X. So I think you need to, as Beth says, visit a few places, see what feels suited to you and your, you know, your personality and what you're looking for in a college.
I also personally think like I don't see the benefit of using the pool because I think like or of doing an open application because I think you're gonna have a preference. Like if you look into the colleges a little bit, there are differences between them, and I think you're gonna have some preference. So I think it's worth just looking into it a bit, personally. But yeah.
Thank you. What supercurriculars do you recommend for law? So what kind of engagement might you be able to do before you come?
Yeah, I mean, some firms will do kind of taster sessions and things that you can do. So that's more about just making sure that it's something that you're going to enjoy. Anything where you get opportunities to, you know, any sort of like public speaking, kind of debating society type things that you could do at school will probably help. Any others, Beth?
I think also you can do like personal research, like the kind of thing that you might put on your personal statement. Like I remember I listened to a podcast about jurisprudence from some professor from Yale, and that was really interesting. So like following your own interests and like reading books and listening to podcasts from authoritative sources.
Yeah. But making sure on your personal statement, like if you say you've listened to a podcast and it's really engaging, then make sure you have listened to the podcast, because it's amazing. Or it's amazing how many students will say that X happened and that caused me to read Y. And you think, but there's no connection. You know, what you're really trying to say is, look, I've read why. Aren't I a student that you want us to take on? And like, because we obviously read an awful lot of personal statements, we're just not really impressed by that. That I've read why because I think I ought to read why. Whereas, as Beth says, if actually there's something that that you've come across and that interests you, then listen to it, and then you've got something to talk about or to add to your personal statement, but only if you actually have. That sounds obvious, but the amount of students that when you say, okay, well, tell me about that, it's quite clear that they haven't really listened to it, or they're not really interested in it. And yeah, that's just a bit of a red flag.
Yeah, you definitely want to make sure that anything that you mention,
Yeah.
you have actually read. And we do
Yeah.
have people every year who mention things that they haven't read because they think it will make them look better.
Yeah.
Not when you're applying to a university that will interview you
Yeah.
and that might ask you questions about it. So
Yeah.
better to have done a few things in depth and really engaged with them than to kind of list lots of things that you haven't actually done.
Yeah.
A question for Beth. How did you find the transition to life at Cambridge and the intensity of studying? Do you ever find it hard to strike a study/life balance, especially with the more condensed terms?
So that's a good question, because in first year I think I probably didn't have a very healthy balance, and it's something I've learned over time. I'd say that I'd say there's enough work to be working like every hour of the day, and so you have to set your own limits. But I think that you can do that in such a way that you can do well and still have a reasonable work-life balance. So yeah, my advice would be expect to work hard and that will be enjoyable, if you're excited about law. But I think also be intentional about giving time to people, not making everything about work, and making time for rest. But I think, yeah, it's definitely possible. You just have to learn to work smart. And I personally, all through my degree, I've taken a day off a week. Every week I take a day off. And I also do stuff to relax in the evening as well. So it's hard. It is a lot of work, but it's not unmanageable.
Yeah, and the students who don't get the balance right can end up burning themselves out or just stopping enjoying what they're doing because they're doing nothing but what, your university life, it is a precious 3 years actually, and it is fun, and you make, genuinely friends for life. I have, my two of my closest friends are my uni friends. So all of that side is really important, and actually I think makes you a better student, because if you allow yourself some downtime, you come back to your studies fresh. And I think Beth's right, it is. And I think especially in the first year, students think that they have to read absolutely everything. And so they read absolutely everything, but they're not really absorbing it because they're just trying to cram so much in. So I think it is about working smartly, and part of working smartly is making sure that you have some downtime, you have some rest, you have good sleep, you eat well, you get some exercise, because all of those things make you more productive, actually. And, you could sit at your desk for 10 hours, but not produce anything more than if you'd sat at your desk at 6 and had 4 hours off sometimes. Yeah.
Thank you. How can we show our enthusiasm in the interview?
Was Beth about to answer there? Or
Oh no, I was just reading the question, sorry.
okay,
Sorry, how can you show your enthusiasm in the interview?
So I think, I mean, just be engaging. Sometimes, like we don't mind if you're a little bit nervous. You're bound to be a little bit nervous. So those sorts of things don't don't phase us at all. But sometimes I don't know. Very, very occasionally, you have students that it slightly feels like they're interviewing for a job at Costa that their mum's arranged for them, and they don't really want to work at Costa. Do you know what I mean? It's like we want you to be enthusiastic about the subject, because actually, if you're not enthusiastic, you will not enjoy it. Don't choose law because you think it's a safe bet or a prestigious degree to be doing, or all the rest of it, because it is 3 years of your life. You need to actually enjoy what you're doing. And if you are genuinely motivated to do law, then I think that does come across naturally. So we want you to be natural as well in the interview. Um, you know, don't tell us that something really, really excited you when it probably didn't. But yeah, so I've listened to some podcasts, be engaged. Yeah, and it will come across.
Yeah, I think that's a good point, especially for law. I know that I've done lots and lots of work with prospective applicants. So some of the people probably here listening, your age range, and a lot of people want to study law because someone's told them to study law because they think it sounds good, or their school or their parent wants them to do law. Please don't do that, as you've just been told. Please look into it. It's great that you're here today because you've had a sense of what it's actually like to study law. But there's also other avenues to go into law later as well, if it's something that you feel you might want to explore at some point, but perhaps not now. That's also an option.
Yeah, so you can become a lawyer, you can become a solicitor or a barrister without having done a law degree. There are other hoops you have to jump through, but plenty of people come at it after having done a different degree. And actually, if the degree's not for you, then probably a career in the law is not for you either. But you don't have to become a lawyer with your law degree. It will open doors for you, but just don't. And I've seen people in student life, but also in my professional life, who've done it because of the sort of supposed status that it gives you, or because their parents have pushed them. Well, are you going to be a doctor, a lawyer, or an accountant? Please choose. And you get one life, so you've got to spend it doing something that genuinely you're enthusiastic about. I decided when I was 7 years old that I wanted to be a lawyer. That's a bit sad, isn't it? But I always wanted to be a lawyer. I always wanted to be a family law lawyer, and I've enjoyed my working life as a result. Work is hard. Don't do it for the kudos. Do it because you actually enjoy it.
Yeah, thank you for that. So moving on to the next question to Beth. This may not be useful, but what subject did you do for your A levels and what were your GCSE grades? You don't have to share if you don't feel comfortable.
So for my A levels, I did history, Spanish, and religious studies. And then in my GCSEs, I got all nines, but I would say, like, I know it's really tempting to always ask, like, always ask, like, what did you get and what did you do, and try and compare your profile with other people. But everyone has different factors in their application, and I'm sure it's all looked at holistically. So, yeah, I take it with a pinch of salt.
Yes, and I would say as well, not everybody does get all nines at GCSEs. We're much more interested in your predictions for your A levels or your current qualifications than those previous ones. So please don't be put off applying because you're unhappy about one or two grades that you might have had in your GCSEs if you're doing really well now, because we are interested in what you're doing now. There's a repeat question. So the one about my friend applied to Homerton, can he reapply? The person wants to say that what if they did get an interview but didn't get an offer? So just to add that in because you asked whether they'd had an interview.
Yeah. So I mean, it's they're not precluded from applying again. So if they wanted to try again, one of my best students, not a Homerton student, but a student that I supervised last year, didn't didn't get in the first year, but really wanted to come to Cambridge. It was a different, as I say, different college, because I supervise for 8 different colleges, although I'm based in Homerton, because that's how it works. You supervise in small groups for different colleges. So one of my best students from a different college didn't get in, but didn't give up, applied the next year, got in to a different college, and has absolutely thrived. Was one of my best family law students last year. He's got pupillage, he's going to be a barrister. So the fact that your friend didn't get in last year, if he really wants to come to Cambridge or to Homerton, what's he got to lose by applying again?
Thank you. Someone says, I'm concerned because I don't remember absolutely everything from the legal books I read. What might a question about a book look like?
So if you put something in your personal statement that said, I read X and I was particularly moved or inspired or whatever by what X said about Y, then at least make sure that you know what X did say about Y. So you're not going to be quizzed on the whole of the book. But if you've said that one particular argument in the book was particularly striking to you, then make sure you've honed up on that one.
Yes, indeed. So interviewers are not trying to trick you. They are not going to kind of quiz you about all sorts of things that that they expect you to know. But as you've just said, if you do say you've done something, then they might think that they are actually being nice to you by asking you a question on something that you, in theory, know about. So be careful about, knowing what you've talked about. Is writing a research paper useful, and does it being published make a difference?
So I think you mean for the doing the seminar paper, the written, the 12,000 word
I
seminar option, I suspect is what the student is what the
It might be about doing it before coming. I'm not sure. Perhaps you want to specify, perhaps for the student who's written that,
okay.
you might want to clarify, but yeah, maybe it's best that they clarify before we
Yeah,
answer that.
yeah.
How can we reflect on activities we have done on our personal statement if we get asked about it in the interview?
It depends what the activity is. So yeah, if it's a law related activity, you might be asked about what you learned from it, you know, I don't know, what the legal issue was that you were looking at, why you were particularly drawn to that. So I suppose it just depends what you've put on there.
Yeah, thank you. And also, if you are interested in it, then you should have something to say.
Yeah, exactly.
You're not kind of performing for people. You are supposed to be there to talk about why you want to be there for 3 years and spend a considerable amount of money and time investing in this course. So you have to view it as this is for you at the end of the day. Does participating in competitions like the John Locke essay competition help our profile?
It certainly doesn't hinder it, because again, it shows that you're committed, that you're interested in law, so all of those extra things just build a picture about you. So none of those things are going to hinder an application. They're going to help you stand out. But remember, we are looking holistically at everything, and the amount of work that the admissions team does in looking across the board is absolutely phenomenal, actually. So we're not just looking for the very best A-level results, because actually, if you're in a catchment area where the average grades are much lower, then that speaks volumes about you when you get those grades. So we are looking holistically at what you're doing, but other extracurricular activities show your enthusiasm. But again, don't just list a whole, don't just sign up to a whole load of things that you're not really interested in and you haven't really engaged in, just so that you've got stuff to put on. I did the John Locke competition. Well, okay, what did you write about? Why did you write about it? Why did it interest you? What did you find? Because if I did the John Locke competition, but you can't really remember what you wrote because you weren't really very interested in the subject matter, is going to almost be a negative. But as Lindsay says,
Yeah.
we are genuinely wanting to find the best students that are the best fit for Homerton. A, because we want you to thrive, but actually, if we find the best students, the Beth Lees of this world are easy to teach because they are enthusiastic and they are naturally gifted at it and all the rest of it. So, we want the best students, because we want Homerton to do well, but we want you to thrive. So we're not in the whole point of the interview is to try to find the best fit for Homerton students in law. It's not to catch you out. We're not there to do that. We're there to see if you're a good fit and if we're a good fit for you too, because we might not
Yeah.
be.
Thank you. I think there's some clarification on the research paper. It's written and published before undergrad application. They've written a research paper on law and they've participated in many essay competitions where they've written regarding law and humanities. Are these of importance while applying?
Well, again, they're not going to count against you. Certainly, if you've had something published, then fine, put it in your personal statement. Um, it you know it can only help, can't it? It's we're not. How could it hinder? It can only help.
Yes. And again, like Dr. Jan Ewing said earlier, it's about what you say about the things that you do.
Mm,
Tell us how you've engaged with it, why it mattered to you, why you enjoyed reading that, whether you agreed with it. We want to see a kind of engagement rather than just you listing what you've
yeah.
done. And
And students do
sorry, go ahead.
sometimes do that. They do just list things, and you can tell almost that they've done these things just to put it on their personal statement. And you sort of, when you've interviewed an awful lot of people, it's very easy to see through I've done it because I thought it might help my application, as opposed to I've done it because it genuinely interested me.
Yes.
Sorry, go on.
And the final question is, are Cambridge interviews recorded and can you get feedback?
No, they're not recorded.
And
They're not
yes,
recorded,
no,
and
they're not recorded.
yeah, and you wouldn't be given specific feedback. You're told.
Just to actually clarify on that,
Oh,
just because I work in
oh,
the admissions team, we do offer the opportunity to get some feedback only after if you have had an interview, you can request feedback, but it's something that comes quite a bit afterwards. If you haven't been interviewed, though, we're not able to give any feedback at that stage.
yeah, okay.
Yeah, so something that we do later on. I think that's the end of our questions, and I know that we've run on by a few minutes. So if no one has any final questions, we will end here. Thank you so much to
Thank you.
Dr. Jan Ewing and to Beth for being here today and telling you all about what it's like to study law at Homerton and at Cambridge.
Thank you.
Have a
Bye.
great evening.
Thank you.
Goodbye.
Bye.